So welcome everyone to this quarter's Games and Interactive Media seminar series. It's the third quarter that we do it, and we again have a great lineup of speakers. As you will see, all these speakers come from very diverse areas. Some are academics, some are from industry, some are talking about music, some are talking about education, and today's speaker is actually talking about law. So what you will notice is that we can really use games as a lens to look at all aspects of society, and the other way around, all aspects of society actually focused onto games. And so today's speaker is Todd Smithline. He is actually running his own law firm, Smithline PC. He's the principal. And this company represents a number of clients, generally in technology transfer, and among those, internet, mobile devices, and so forth, and of course, games are part of his portfolio as well. And one thing he told me he's actually most proud of, and that's also how I found him, for the last 6 years, and now in the 7th year, he is teaching a class at Berkeley to law students about video game law. And so give a warm applause to Todd.
Well, thank you, Ingmar, for having me. I'm thrilled to be here. How many of you are involved in one way or another in making video games? And how many of you play video games? OK, great. So this is going to be perfect for all of you. How many in the room, any, are law students, lawyers, law faculty, anything like that? OK. And for the rest of you, do you have any familiarity whatsoever with the notion of copyright? OK, great. So today we're going to be talking about how the doctrine of copyright law is evolving based on cases that are moving through the system relating to mobile game clones. And in particular, I'm going to be making the argument today that these cases dealing with mobile game clones are changing how copyright law works and ultimately changing it for the worse. I figured if I was going to come talk to you today, I'd sort of make an argument about something instead of just trying to explain how copyright law in video games works. So that's what we'll be talking about today. I will tell you, as Ingmar says, I teach video game law at Berkeley, and we typically have 13 sessions of 1 hour and 50 minutes each to get through this material. We're going to get through it today in 40 minutes. Since you're a Stanford audience, I'm assuming that's going to be OK. But I will ask that we hold the questions until the end, unless you have very important objections, and then raise your hands, and we'll address that. Otherwise, questions, objections, thoughts, comments at the end. Really quickly, I am the principal of a law firm. We're 6 attorneys up in San Francisco. We do technology transactions and IP licensing. But today, I'm here by myself, not on behalf of my law firm, certainly not Berkeley or anything like that. So these are my views. Some of the decisions we'll be talking about today happened at a preliminary phase in the litigation. And I will point that out as we go. But just so you know, that's the case. And finally, I have a list of sources here. They'll be at the end of the presentation. And certainly, if you're interested in the topic and you want to learn more, I've got endless books, articles, and other thoughts I can refer you to. So just let me know at the end. OK, so let's do it. What are the rules of a video game? And again, today, I'm suggesting that copyright law is changing in terms of how the courts deal with the rules of the game. Traditionally, courts have not protected the rules of the game under copyright, and I'm suggesting that that is changing. But before we take a look at the cases and before we look at the games, we need to start with the question of what are the rules of a video game? Well, let's start with board games first, and I have 2 up here, which we'll get to a little later in the presentation. For a board or a card game, the rules are the set of instructions that explain how to play the game. And they may also include the method of playing as expressed through things like scoring charts, the game board, and the pieces. So the rules of the game are what you get when you open the box and pull out the rules. These are the rules of the game Bang, and these are the rules of the game Legends of the Three Kingdoms. And you fold out the rules and you learn how to play. But as I'm also suggesting, the rules can be expressed through the tokens and the pieces and the game board itself. I think it's fairly easy to understand what the rules of a board game are. So then what are the rules of a video game? Well, for a video game, the rules are often also expressed through the mechanics of the game or the gameplay. These are functional rules which dictate how you can move a character, how points are scored, and when you win and lose. Bruce Boyden, who's at Marquette, talks about the limits and affordances of the game. And another way to think about the rules of a video game are to think of video games as systems. And again, Bruce Boyden's words, systems into which the users pour meaning when they play the game. But in any event, the rules of a video game are not a list of instructions per se, although they can include instructions, but are also what you do while you're playing the game and what you're allowed to do. So when you're playing Donkey Kong and you're Mario, the rules of the game include the fact that if you get hit by a barrel, you're going to lose a life. And they include the fact that you can only get from one level to the next when you climb a ladder. And they include the fact that you're going to clear a level if you get to the damsel in distress at the top. These are all the mechanics of the game, or what we'll be referring to today also as the rules of the game. The rules of the game can also involve things like the fact that armor is very heavy, and if you fall into water wearing a lot of armor, you will sink to the bottom of the sea. Okay, so we're talking about mobile game clones today. So what's a clone? Well, this is easy. A video game clone is a game which follows another game to market and which copies as much of it as they can possibly get away with. And we see this happen quite a bit in the mobile game space, and you're all probably familiar with clones that you've seen in the Android marketplace or in the Apple store. But essentially, a clone is just a copy of a game, sometimes comes very close, that's trying to capitalize on the success of the game that came before. Here we have Tetris on the left and a game called Mino on the right, and we'll revisit these in a minute. But this is a clone of a video game for purposes that we're using today. Clone is not a word in the copyright code, but I think you all understand what it means. So that's what a clone is. All right, so historically, game rules were not protected by copyright. So why do I say that? Well, first, we have case law to tell us that. R.F. Foster published a series of books about the rules of bridge. And in one of the books, he included the rules for a type of auction bridge called whist. And after he publishes the book, he hears from the Whist Game Society, which claims that he has copied their rules and infringed their copyright in the rules. And the court looks at this and says, well, that's not copyright infringement. The court says, in the conventional laws or rules of a game, as distinguished from the forms or models of expression in which they may be stated, there can be no literary property susceptible of copyright. Defendant has not infringed because he has not copied the literary composition of the plaintiff's publication, but in language quite distinctly his own, has restated the same set of conventional precepts. This is 1929. This case is still cited too. The idea is you copied the rules of whist bridge, but you did not copy the creative expression. And whatever you copied, you're allowed to copy because they're just the rules of the game. So we have case law that tells us that the rules of the game are not subject to copyright. We also have the Copyright Office. This is a circular from the Copyright Office on copyright in games. Copyright Office tells us copyright does not protect the idea for a game, its name or title, or the method or methods for playing it. Once a game has been made public, nothing in the copyright law prevents others from developing another game based on similar principles. So that's what the Copyright Office tells us. And then we have the best source of all, the Copyright Code itself, 17 U.S.C., and we learn that copyright subsists in original works of authorship fixed in any tangible medium of expression, but excludes any ideas, procedure, process, system, method of operation, concept, principle, or discovery. So to sum it up, copyright protects the expression of ideas, but not the ideas themselves, or functional processes or systems. That has been the state of the law, of copyright law, generally speaking, in terms of copyright in the rules of games up until quite recently. Now, we're going to look at some cases where the court has been asked to compare two games and make a decision as to whether they're too close to each other and therefore infringing the initial publisher's copyright. But before we do that, we need to spend one more minute on the law and understand how infringement analysis works. So what are the steps that a court takes when presented with the question of whether two games are too close to each other? When the court was asked, is Mino, as I showed you before, too close to Tetris, what are the legal steps they go through? Well, first you need to understand that video games are protected as audio-visual works. They're also protected for their underlying computer code, but we will not be getting into that today. So we focus on expression. So what is an audio-visual work? Well, quite simply, it's the element of the game that you perceive with your eyes and your ears. It's what you see on the screen. It's the sounds you hear in your ears. That's the audio-visual work of a video game. And that audio-visual work is what copyright protects, the expression in that work. OK, so when we're comparing two games, first, we filter out the elements that are not entitled to copyright protection. First, we filter out the ideas of the game, because as we saw, ideas are not protected by copyright, only expression. Secondly, we filter out something called scène à faire, which are stock or cliche expressions which necessarily follow from the idea. So if I'm making a game about putting out fires, I'm going to have a fire station, I'm going to have an alarm bell, I'm going to have a pole that people slide down, and I'm going to have trucks racing at high speeds down city streets. These sorts of cliche or stock expressions, the courts refer to as scène à faire, and the courts will allow copying of those types of expressions, not the exact version of it, but the general ideas and concepts and precepts without finding copyright infringement, because they say if you want to have a game about putting out fires, they're going to have to be trucks and hoses and firemen and cats stuck in trees. That is essential to telling that sort of story through a game. And then finally, the courts are going to filter out the rules of the game. And the rules are going to come out either because they're ideas or because they're systems. One of the two, it doesn't really matter, but we do not protect under copyright, or at least we're not supposed to, the rules of a game. So we filter out the things that copyright does not protect, and then we compare what's left. And we ask the question, is what's left, is the protectable expression that's left substantially similar? Are the two games still substantially similar? And if they are, then we have copyright infringement. OK, so that's what the courts do. One last note, the courts afford thin copyright protection or lesser copyright protection for more factual or prosaic expressions, and stronger protection for more fanciful or unique expressions. Again, if you look at the copyright code, there is no section on what's a thin copyright or on what's a strong copyright. But this is common law, judge-made law. But over the years, the courts have said, if your expression is highly fantastic and original and creative and unique, we are going to afford more protection to that under copyright. But if what you're doing is more factually based and is simpler expression, then we're going to afford less copyright protection. And this spectrum of protection is important to understand when we get into the cases. OK, so that's copyright law on a single slide. And that's what courts do when they're comparing two games and ask to see if one infringes the next. So how did courts, if I'm up here suggesting today that the law has shifted somewhat, how did courts previously separate ideas or rules from expression? How did they previously deal with the doctrine of the rules of the game? And let's look at two of the most important early cases in video game law. The first involved asteroids. On the left, this is Atari's first big hit. Actually, was one of the single largest grossing titles that they ever released. This is one of the top-selling coin-operated arcade games of all time, and one of the very early coin-operated games to come to the market. Asteroids comes out. It's a vector graphics game. It's actually one of the last games made with vector graphics. And soon after follows Meteors. So we did have clones from the beginning of video games. It's a great story behind Meteors. I don't have a chance to share it with you, but this is the last known remaining Meteors machine. It was restored by the son of the gentleman who actually created the game. It's unknown whether he actually used the same computer chip underneath and just changed the graphics on top. But in any event, he brings the game Meteors, and it's awfully close to Asteroids. In fact, Meteors is so close to Asteroid that the court says, to put it bluntly, defendants took plaintiff's idea. However, the copyright law does not prohibit this. The court says, absolutely stole the idea, but we don't protect ideas under copyright law. So we have to look at what we do protect and decide if what's left is substantially similar. So the court identifies 22 similar design features and identifies the principle of the game as being the same. And by the way, that's the court's language, design features. Today we would probably use the word game mechanics instead of design features. But if you've ever played Asteroids, as you know, you're in a spaceship, you're shooting at rocks. The sound increases, the speed of the rocks increases. As you hit a large rock, it busts into smaller rocks. There are 2 spaceships flying around which are trying to shoot at you. Meteors has all the same gameplay. But it did have some differences than the court identifies. 9, and a few of the important ones. Meteors was in color, Asteroids was not, and the court thought it was more realistic looking. The spaceship in Meteors initially takes off from Earth at the beginning of the game. It has slightly faster gameplay, and you're able to fire continuously. Those aren't the only differences, but those I think are the most important differences between the 2 games. And what does the court hold? The court holds no infringement. The court says these similarities are inevitable given the requirements of the idea of a game involving a spaceship combating space rocks, and given the technical demands of the medium of a video game. Now, you're sort of chuckling, like, you know, the court is recognizing that there's a genre of games now of spaceship shooting space rocks, but the court is saying if you wanted to make a game in which you have a spaceship flying around in space shooting at space rocks, you're inevitably going to have a lot of this same expression. And whether you want to call that game rules or game mechanics, the court here is saying that's not infringement. So this is Meteors versus Asteroids. The next big case we get a year later, and Meteors was a district court case, although it's proven to be very influential, not strictly precedential. This is a 7th Circuit Court of Appeals case, which is a higher level in the court system and actually does set precedent within that circuit and is persuasive in other circuits. And this is Pac-Man versus Casey Munchkin. And here you have another one of the highest grossing games of all time, both in the arcades and also in the home version. And here you have both on the left of Pac-Man, and you have Casey Munchkin, just the Odyssey version of Casey Munchkin on the right. This is the Atari 2600 version of Pac-Man. This is the arcade version. I'm showing you both just to give you a picture of the game. Strictly speaking, it was this version of the game, the home version, that was accused of being infringed by Casey Munchkin. In any event, Casey Munchkin comes out and Pac-Man, the publishers of Pac-Man sue and say, you cannot have your game be as close to Pac-Man as you've made it. You have infringed our copyright. And this turns out to be a very interesting case. So the court looks at it, and at first the court says, look, there's some similarities here we're going to allow as standard game devices. We're going to allow the maze design. We're going to allow the scoring table. We're going to allow the dots. Now, there was a difference in the number of dots. There are a lot more dots in Pac-Man than there are in Casey Munchkin, but the action of eating the dots and what the dots do plays the same in both games. And we're going to allow the tunnel exits. And on the tunnel exits means you can exit the screen to one side and pop in on the other side. And the tunnel exits are interesting. The court says these are nothing more than the commonly used wraparound concept adapted to a maze chase game. Now understand, this is very, very early in the history of video games. We've hardly had any cases yet at all, and already the court is identifying the commonly used concept of a wraparound game. So the court says all those things Casey Munchkin you're allowed to copy. But the court says what you copied that you weren't allowed to copy were these, the exact Gobbler and the Ghosts. They said that's where you stepped over the line. The court says the Gobbler and the Ghost monster characters infringe. The Gobbler was virtually identical to Pac-Man. The shape of the body, the V-shaped mouth, the distinct gobbling action and sounds, and role reversal and regeneration. As you know, in the game of Pac-Man, when you eat the dot, you are now allowed to go after the ghosts, and that times down, and then the ghosts come back after you. So Casey Munchkin had that same gameplay, and the court said that's going too far. But this remains, I think, an important case because the court was willing to look at the game and say, these are the things that are not protected by copyright, and these are the things that are, and the things that are the characters, and the things that are not are the common, more gameplay-related elements of the game. So these are the first 2 big cases we have. And frankly, then we sit a while before we get a lot more video game cases. And there are a few more, but none I think that are better illustrations than the one I've shown you. And there's a reason why we don't get a lot of litigation for a while, and that's because you have the rise of large game studios and large gaming platforms and bigger budgets, and you have a maturing industry. And as it happens, the mature content industries don't tend to sue each other very much over their content. But then something changes, and what changes are mobile games. So mobile games come along, and all of a sudden now we have a lot of game production, a lot of copying, and now we have a lot of copyright litigation as well. So here's the first case, the first really, I think, important case in the mobile clone wars. And this is the one I showed you at the beginning of the session. This is Tetris on the left, and this is Mino on the right. They're pretty close. The publishers of Mino put out a game that is basically Tetris. They changed the expression just a little bit in terms of the pieces. And you might be thinking, well, they're just, what are they thinking? This is totally crazy. They've totally copied Tetris. But they had a very interesting theory. And their theory was that everything they were copying in Tetris was actually a function of a rule of the game or the mechanics of the game, but were not creative expression. So they felt that they could put out a copy of Tetris because the expression of Tetris, such as it were, is completely driven by the function of the game, and they are allowed to copy that. This did not go over extremely well, however, with the court. The court did start off fairly well. The game mechanics and the rules are not entitled to protection, but then we get this big but, and then it follows for page after page after page. The court says this distinction between a game's rules and its appearance is merely an application of the familiar idea-expression dichotomy as applied to games. It's not a very availing sentence. It's not actually a very availing opinion. But the bottom line is the court pays some lip service to the notion that we are not to give copyright to game rules or game mechanics, and then goes on to find infringement. But it's actually the way the court found infringement that I think is very interesting, and that is having an impact on copyright law more generally. The court found some very functional aspects of this game to qualify for copyright protection. Here's a list of things that the court says are not part of the idea or the rules or the functionality of Tetris, but are part of the expression, okay? We start off with the fact that the court is protecting the design and movement of the playing pieces, including bright colors, the individually delineated squares within the pieces, and the downward, lateral, and rotating movement. The court found that to be protected by copyright. The court also found the 10 by 20 dimensions of the playing field to be protected by copyright. The court found the display of garbage lines to be protected. A garbage line appears at the bottom of the screen at higher levels of the game to make it more difficult to play. The court found the appearance of a ghost or shadow piece, this is the ghost piece. It tells you where this piece is going to land when it hits the bottom, if it stays positioned where it is on its way down. The court found that to be protectable by copyright. Then the display of the next piece to fall. So the next piece to fall is what you see over here. Those are the next pieces to fall. The court said that's protected by copyright. And the change in color in the accumulated pieces when they lock at the bottom, so you know if you complete the field and then you get all one color. That's protected by copyright. So here you have, and finally, the appearance of squares automatically filling in the game board when the game is over. Okay, so if you don't complete the board and your turn ends, then it fills in for you. So this is maybe an example of what we call bad facts making bad law. So we have a case where the games are virtually identical and it goes to trial. And the defendant here, the publishers of Mino, the clone, took this theory to trial that we are allowed to copy Tetris because nothing in the Tetris game is protectable by copyright. And they lost big. And what I mean by that is we get this decision describing all these very functional things as protected by copyright. There's an interesting quirk as to why the functionality of the game is so prominent in the decision, and that's because Tetris is actually released in many, many different versions with many different appearances. So Tetris Holdings, which is the company that owns Tetris, described to the court in its filings what they thought they had copyright in using this kind of language, as opposed to just the exact appearance of the game itself, and the court took them up on that and put that in their decision. So that's how this resulted. Now, this is a 2012 case. This is the District Court of New Jersey, but this case never proceeded any further. So while technically this is not precedential, meaning no court, even another district court in New Jersey, has to follow this, when you have a video game case in front of you and you're sitting in the chambers in a district court somewhere or in an appellate court in the US, you're going to look up all the video game cases, and this comes up, and the other courts read it, and they're influenced by it. So while it's not directly binding precedent, it's deeply influential. So that's Tetris versus Mino. That's the first case. Second case is Tripletown versus Yeti-Town. This is Tripletown on the left, Yeti-Town on the right. This is what they call a match 3 game. You click on 3 bushes and it becomes a tree, and you click on 3 trees and it becomes a hut. And basically, you fill in the spaces on the game board by clicking, 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 and you get points as you complete each match of 3. And you are invited from time to time. Would you maybe like to share your email address? Would you maybe like to buy some virtual goods? And that's the game of Tripletown. So Yeti-Town comes along, and they put out the game you see on the right. Similar looking game board, also a match 3 game, also same dynamics, but they changed the look. They recast it from a sort of pastoral, maybe springtime scene to a winter scene. And as you'll see in a minute, they changed the objects and the animals. And they are sued for copyright infringement. So what does the court do with this case? Well, first, the court, again, starts off well, in my opinion. The rules of the game are entitled to, at best, thin protection. Game rules are a hybrid of the concept of the game and functional considerations. So, OK, looks like the court is going to put the rules aside and say that we're not going to find copyright infringement for copying the rules. So they say, for example, the rule that players progress up Tripletown's object hierarchy by forming groups of at least 3 adjacent objects is part of an extension of the idea of a matching game, and in part a functional consideration to make gameplay interesting. So clicking on 3 objects is an extension of the idea of a matching game, and it makes gameplay interesting, and it's a functional consideration, and it should be considered a rule of the game. And the court allows some other similarities, exchanging coins for a strategic advantage, the 6x6 grid, the pricing structure in the marketplace, and the strategic limit on how many advantages a player can purchase. But then we hit rough waters, because ultimately the court finds there is infringement here. And what the court finds as infringement is a combination, or the combination, of what they call the object hierarchy and the play of field. So what's the object hierarchy? Well, the object hierarchy is this. In Tripletown, you go from grass to bush to tree to hut. And in Yeti-Town, you go from sapling to tree to tent to cabin. And the court says those object hierarchies are similar. In fact, they are so similar that when combined with the field of play, which we'll get to in a second, that's copyright infringement. So what's this thing about the field of play? Well, the court says the depiction of the field of play comprise a setting and theme that is similar to Tripletown's. The court says that a meadow is not so different, a snowfield in Yeti-Town, not so different from a meadow. And a yeti in Yeti-Town and bears in Tripletown are both wild creatures. And a plain in Yeti-Town is plausibly similar to a patch. Now, this word not is not supposed to be here. It's a mistake in the opinion. We would use the little phrase sick to point that out. I've left it in here on purpose to make a point, which I'll get to in a second. But the bottom line is the court finds infringement here. And what the court says is that even though you changed this expression from meadow to snowfield and from bears to yeti and patch to plain, when combined with that object hierarchy I just showed you, that constitutes infringement. To a copyright lawyer, this is really problematic. And I would argue to anyone who is involved with creating expression, this is really problematic. This is not how we typically think about copyright. We typically think that a snowfield is in fact very different than a meadow. Those are totally different types of expression. So this is really, I would argue, taking things to the next step and really capturing the functionality of the game or the rules of the game and giving that copyright protection. That case, which is the Spry Fox case, also settled. And it's settled with the owners of Yeti Town transferring the IP in their game to the publisher of Triple Town. So we will get no further decision from any higher court or even from that court in that case. All right. The third case we're going to discuss, and really the reason I'm here, or I was excited to be here because I really thought I had something to talk about, is a case where this type of thinking about mobile game clones has leaped species to board games. And these are the two games you see in front of you here on the table. This is Bang, and this is Legends of the Three Kingdoms. Has anybody ever played either of these card games? And which one have you played? Okay. You played Legends. Okay. Did you know about the case?
I heard about it, but I don't
Okay.
know anything.
So Bang is a great game. They're both great games. And you're assigned a role. You're the sheriff. You're the renegade. You're an outlaw. And you sit around a table. And you draw 2 cards each turn. And you have weapons. And essentially, everybody's trying to kill the sheriff. And you have powers that you can draw, which put other people in jail, or which protect you from getting shot, or which move you closer to somebody so it's easier to shoot them. It's a role-playing game. Bang is set. It's a spaghetti western. It's literally an Italian game with a spaghetti western theme. And Legends of the Three Kingdoms is a game set in the, I guess, 200 AD or so China, the Three Kingdoms period. And what the creators of Legends of the Three Kingdoms did is they actually brought to life a law school hypothetical, sort of maybe a gift to all law teachers everywhere, which is, in my opinion, they copied all of the rules of the game and none of the expression. And this goes to court because the publisher of Bang alleges Legends of the Three Kingdoms has infringed their copyright in the game of Bang. What happens? Well, the court begins by noting that the transposition and translation from the Wild West theme of Bang to the ancient China theme of Legend is important and needs to be considered for copyright infringement purposes. They also acknowledge that the specific capabilities that a character may have or use are in themselves an unprotectable part of the rules of play. So far, so good. But then we get another but. The impact that artwork has on the total concept and feel of a role-playing game has less relative significance than the manner of gameplay that the creator defines through the expressive choices such as player roles. So, again, almost all of the roles of the players and the attributes of the players between the two games are the same. Legends of the Three Kingdoms has a few more characters and a few different rules. But the rules are the same in terms of how many health points each character has and how hard it is to kill them and what happens if they die. But the expression is totally different. And to sort of test this out, we had a little gameplay session at the office with some of my Berkeley students. And we looked at first we looked at just the cards. And you put the cards on the table and you ask yourself, can I tell if there's infringement here if all I looked at is the deck of cards, if I don't have the rules? And the answer is very hard to understand, except for that some of the cards, for example, Calamity Jane has 4 bullets, and this character has 4 life points. It's a little hard to see here. But looking at these 2 cards, and maybe from reading the rules, you might see some similarity. But it's basically very hard to tell that these games are similar to each other until and unless somebody walks in the room and gives you this, which tells you how to play the game, which is how to make these 2 things actually work. And once you do that, you see a lot of similarities, but you see similarities in the characters' attributes and traits. The court found the 7 characters from Legends have capabilities and life points that are identical or substantially similar to those of the corresponding 7 characters in Bang. And the court finds that the players' roles and the interplay of the characters is the same. So, here you see on the left the sheriff card or the sheriffo card in Bang, and you see the monarch card, and these both play the same role. The expression, as you can tell, is totally and completely different. The names are different, and what is evoked in when you play the game is totally different between the Three Kingdoms period of China and a spaghetti western theme in the US, but the mechanics are the same. So the court says, just as the progression from grass to bush to tree to hut was protectable expression in Spry Fox, and Spry Fox is the Tripletown case, so the interplay between sheriff, deputies, outlaws, and renegades is protectable expression here. So you see the court, and this court also cited to the Tetris case. They look at the Tetris case, they look at the Tripletown case, they say, you know what, even though this isn't a video game, we think that the same thing is going on here. You've copied the interplay of the characters, you've copied the capabilities of the characters, the gameplay, the mechanics, and we think that's copyright infringement. I will note this ruling was on a preliminary motion to dismiss by the publisher of Legends of the Three Kingdoms, what we call 12b-6. The case moved forward, and we are currently awaiting a ruling on summary judgment. So this is being litigated on behalf of Legends. Well, I won't go into who the lawyers are, but the bottom line is we are waiting on a final summary judgment motion, and then we will see whether this law is going to stand or not. That same judge, we are now at a further point in the trial. The first ruling that I just shared with you was from an early motion by Legends of the Three Kingdoms to have this tossed out basically on the papers, meaning that just on the games themselves, they made the argument to the court, there's no infringement here. We didn't copy any expression, we just copied rules. The court said no, and now we're waiting for a further decision. All right, so where are we today? Tetris versus Mino, I would suggest, copied all 100% of the rules. And let's face it, if that bar isn't even high enough, 90, 95, 98%, whatever you want to call it of the expression, court says that's infringement. Then we move on to Tripletown versus Yeti-Town. Again, 100% of the rules are copied, and I don't know, maybe half the expression, depending on how you want to look at it. They did, in fact, change the characters and the setting of the game. In any event, that's infringement. Now we have Bang versus Legends of the Three Kingdoms. We have, again, basically 100% of the rules copied. I mean, I think Legends would make the argument some of the rules are slightly different, but let's just say almost all, if not all, the rules are copied, but very little of the expression is copied, unless you consider capabilities and roles to be expression. And I would argue, even if you do consider capabilities and roles to be expression, maybe 5%, 10% of that game is copied. Yet we have infringement, infringement, infringement. And so this, I think, illustrates what's going on with copyright doctrine right now and the impact that these mobile game clones are having on copyright law writ large. So you might be sitting there asking yourself, hey, wait a minute, is there some other way to protect the mechanics of gameplay? And the answer is, yes, there is. It's called patent law. And in fact, you can get a patent on the mechanics of gameplay, on the rules of a game. You cannot get a patent, strictly speaking, on just the rules of a game. If you write the rules down on a piece of paper and submit that to the patent office, you are not going to get a patent issued. But if you drop an invention, a description of invention that involves rules and gameplay, that involves any other system or process or method, you absolutely can get a patent on that. Here, I'm sorry, it's hard to read. This is a Microsoft patent, but this is a patent on systems and method for providing a game achievement system where players are rewarded with game achievements based on mastering certain in-game facets of the games they play. These are little trophies. These are little ribbons. These are things you're awarded in the game. So Microsoft, this is a 2011, I believe, patent. But in any event, 2011 patent, Microsoft on awarding little digital trophies and other things within games. Patents are difficult to get. We'll talk in a second about the hurdles you have to overcome to get a patent. But the bottom line is, if what I'm saying is correct, that games are systems, that the rules of a game are a method or process of playing the game, you can protect systems, you can protect methods and processes, and that's patent law. Okay. Why is this happening? And I've alluded a little bit to this as we've gone along. Why is there so much copying? Well, first of all, mobile games are relatively cheap to make, but there's huge potential upside. So a hit mobile game can do $1 million in revenue a day. This is a US $3 billion industry this year alone. So there's a lot of money to be made. Maybe there's a lot of copying because of technical constraints. And I would encourage you all, you can play Tripletown for free. You can download it. You really don't need to know much about the rules of the game. You just find yourself clicking and clicking and clicking. It's basically like playing slot machines. You don't even need to know what you're doing. You just click and bubbles of points pop up and screens change. But there's a limited number of ways you can interact with a device, and there's a limited number of ways you can control a game on a phone. So that might be why we're seeing some copying. And finally, there's a global market for both the games and the developers. So if there's a hit game that comes out, developers all over the world can immediately write a clone and distribute that clone. So we have a global market both for sales and for developers. So why these court decisions? Well, there's a larger trend towards stronger and longer copyright. We used to have two 14-year terms, one 14-year renewable to 2 to 28 to 42 to 56 to 75. And the last time we extended copyright in 1998, we went out to 95 years. So the general trend in copyright law has been to broaden both what copyright covers and to have copyright extend for longer periods of time. Secondly, these side-by-side comparisons do look problematic. If you look at Tripletown and Yeti-Town, you look at that and say, hey, wait a minute. It really looks like something's being ripped off here. But my contention is, sort of where is the slide to the left? And what I mean by that is that if you are going to start to protect the functionality of games, then you have to allow the defendant to introduce evidence of other games which came before which use the same functionality. That's the system we use when we award a patent. So copyright, unlike patent, does not have to be novel. That means it does not have to overcome prior art, and it doesn't have to be non-obvious. If you want to go get a patent on game mechanism, you have to prove two things to the patent office. One, you have to prove that nobody has done this before, and they literally go look. And they look on the game. Now, somehow Microsoft got that patent through, but they literally look to see, have there been any prior patents or any prior publications or any prior games in which we awarded a little digital trophy when you accomplish a certain task. That's the first step. We call that prior art. You must also prove, by the way, that your invention is non-obvious, meaning that it's not just the next obvious step of development in that particular field. You don't have to do either for copyright, but my contention is if we're going to award that kind of protection under copyright, you should have to do the same. For copyright, you only have to prove that it was independently created and possesses a modicum of creativity. And finally, I think this might be happening because the courts aren't playing the games. In fact, the Tripletown case, flat out, the judge says that neither Spry Fox nor Sixwave, the two publishers, suggested that the court should compare Tripletown and Yeti-Town by actually playing them. The courts are not playing the games when they come to chambers. They are making their decisions based solely on the exhibits of the parties, some of which you saw, like the two cards next to each other or the two screenshots next to each other. And it's very difficult to understand what's going on in a game unless you play it. But the courts are not playing the games. All right, so what is the result? If this is true, that we are now starting to protect the mechanics and the rules of the game under copyright, what's the result? And of course, this is the result. We don't know. So there are lawyers within 5 miles of this campus who right now are on the phone with somebody making a video game, whether they're at a law firm or whether they're at a video game developers, a video game development or publishing company, trying to answer the question to their client, which is, what am I allowed to copy from a pre-existing game? I want to make a game. I want it to be dissimilar to this other game. What are the rules? What are the boundaries? And it used to be you could say to your client, look, you can copy the idea and you can copy the general mechanics. Don't copy the expression. Now that conversation goes differently. And it's a much harder conversation to have because you have to warn the client, well, you probably can't copy some of the mechanics of the game either. Don't copy the object hierarchy. Don't copy the field of play. Don't copy the next piece to fall. You can see how that becomes a more difficult conversation and therefore leads to less creativity, less output, more careful consideration of the creators, and therefore, who knows? I mean, literally, we don't know what the result of too tight of copyright control is because we don't see it. It's just a blank screen. Last point I want to make, and I know it's been a lot, is that none of this is new. So the entire video game, the history of video games is based on copying. This is the first most widely published video game, which is Pong, Atari Corporation. This is the first game that shows up in arcades. This is what kicks off the entire video game revolution. And it turns out that Nolan Bushnell of Atari had seen Odyssey Tennis before they made Pong and awfully similar looking games. Here you go, and this is Pong, and this is Odyssey Tennis. But it even goes back further because all of American popular culture and music, books, movies is derivative. Something came before. Even, what would you suggest is our most important American copyright? Does anyone want to hazard a guess? This is a copyright which is so important that the last time it was possibly going to fall into the public domain, Congress in 1998 extended the term of copyright one more time to 95 years. They were also bringing us into compliance with the Berne Convention and what the Europeans were doing, but I think a very good argument can and has been made that it was the lobbying of this one company which persuaded Congress to extend copyright.
We have had Lawrence Lessig here.
Yes,
Mickey Mouse.
You know Mickey Mouse, right. Mickey Mouse. Well, do you know Oswald the Lucky Rabbit? Because Mickey Mouse is awfully similar to Oswald. And our friend Walt Disney, and this is the lodestar American copyright. You don't get more American and you don't get more important in American copyright history than Steamboat Willie. Well, it turns out that Mickey had a precursor. He was called Oswald the Lucky Rabbit, and we have Walt Disney, and he's working for Charles Mintz, and Disney has just made the Alice cartoons, and then he's making Oswald the Lucky Rabbit, and these are selling very well, and he goes to meet with Mintz, and they have a disagreement over royalties, and Walt decides, I'm not working for Charles Mintz anymore, and while he is still finishing his contract with Charles Mintz, he goes back to his buddy Ub Iwerks, who is actually the person in most histories who is known to have actually drawn both of these characters. It wasn't Walt Disney himself. Walt either participated in the creation of these characters to some degree, but they were, I think it's been well established, both characters were drawn by a guy called Ub Iwerks. This is his Walt's collaboration partner. Walt goes back to Ub and says, we are not going to work for Mintz anymore. We are going to come out with our own character. So they come up with Mickey Mouse. They complete their contract with Mintz. And boom, here comes Mickey Mouse. So we go all the way back to the beginning. And what do we find? Copying. Okay, this is how American culture works. And the final question then is, where do we draw the line? What do we protect and where do we allow freedom? And if you're drawing the line at the rules and the mechanics of the game, I would argue you're going to stifle a lot of expression completely unnecessarily. And that is my presentation.